about to go inside here. I'm gonna keep the camera on, but it's gonna be downward, so stay tuned.
All right, how are you doing today?
I'm fine. How are you, sir?
Great. Have a seat, relax.
Absolutely.
Mr. Williams, sir?
Yes, I am.
Mr. Attorney, would Mr. Williams want to converse a little bit?
I think it's best if we just,
There's
in
nothing
front
to-
of the court judge, whatever, I mean, I've attempted twice to provide the defense discovery. He doesn't seem to want discovery. I have an offer. I have not spoken to the defendant since he emailed me back on January, I believe, the 5th. That offer is as to not interfere with any benefits he may have federally. He may receive some military benefits, universal disability. I was going to see about dropping it to a misdemeanor class A, a lesser included offense, for back time. I think the court found out he has around 25 days back time, so it would be just a plea guilty to a back time for a misdemeanor, and that's the offer from the state.
No, not at all. Only a dismissal. I'm currently suing counsel here, so it's a violation of due process for him to even be in these proceedings right now. The state have had 2 years to prove jurisdiction, and from what I believe, jurisdiction comes before prosecution. So until he proved jurisdiction, there's no way that this court or he and these allegations will move forward. I will not be accepting anything short of a dismissal. I provided you with a recount of the case, a summary that I'm pretty sure the court has read as well. So he hasn't proven jurisdiction. Jurisdiction is the most key fundamental element of any legal proceeding. Without it, he or the court cannot proceed. He's not provided any jurisdictional facts. This case arises from a case that was already dismissed for fraud. Okay, so this is another fruit of the poisonous tree. This case cannot possibly survive when the initial case was dismissed. So this is nothing more than a malicious prosecution, which he's already under civil scrutiny for in a Western District. So I don't know if he had informed the court, but he should not even be here, sir. Should be someone else.
Well, I've read what you said, but I think if you don't want to accept anything and you're not inclined to dismiss it, I think it has to go to trial.
No, I've already, sir, with all due respect, I filed a motion to dismiss on the record twice. He hasn't responded to anything. We're not going to go to a trial. All we're going to do is just continue to have federal lawsuits.
Well, sir, I guess we can have a trial without your participation.
That will never happen, sir. That's illegal. It's a violation of due process. He has to prove jurisdiction first on the record, which he hasn't done.
Sir, that's why you have the trial.
No, we're not going to. You don't go to, sir. You're putting the cart before the horse. Trial does not come before jurisdiction. Jurisdiction comes first. So, ma'am, I ask you, what jurisdiction or what form of jurisdiction are you operating under?
I've only been a judge for a little over 50 years, so I'm sure you know the law better than I do.
No, your time and service is great, and we appreciate your work. However, you should be aware that this court is constitutionally defunct. Okay, so as a man of the law, I don't know why you find this funny, but as a man of the law or a judge, you should be very impartial instead of cooperating with the state, which it seems that you're doing. I filed motions to dismiss. I filed unrebutted affidavits. He and the state have yet to respond. So how are we going to go to a trial and you haven't responded to any of the motions or any of the affidavits on file, sir? An unrebutted affidavit stands as fact. It doesn't?
So all I can tell you is that one of the elements of a state's case is that they must prove the jurisdiction and venue. There's no requirement prior to a trial for them to prove that.
Yes, it is, sir. I've challenged it on the record. Once it's challenged on the record, it must be proven on the record. That is law. That is constitutional. You still have yet to tell me what form of jurisdiction is this court operating under.
Well, sir, no one's required to tell you that.
Yes, you are. Yes, you are. By law, you are required to inform me of what jurisdiction you're operating.